My name is Stavros Brekoulakis. I'm the inaugural professor of Michael and Laura Hwang in International Arbitration at the Faculty of NUS. My main expertise is international arbitration, international investment law, international commercial law, and all issues in relation to dispute resolution in international law more generally. Indeed, the relationship between international law and politics has always been one of a struggle. We sometimes think, probably misplaced, idea that law is insulated from politics. We're all hardwired positivists. But it's not true. The way that politics, political context evolves, always has an effect on how international law evolves. So I like to conceptualize the relation between international law and politics as more of one of struggle, a pendulum, a zero-sum game. Whatever the analogy, the main idea is once international law expands, politics decline and vice versa. Just to briefly give an overview of how they evolved in the last 60 years, I will start with this. After the World War II, and in order to address all the horrors of this awful world catastrophe, international liberal lawyers considered that more international law, more institutions were necessary to build a rules-based global democracy where most actors would abide by most rules most of the time. So they engaged in an active, almost frantic treaty building, institutional building that gave us a number of the institutions, international treaties that we now know. The UN, Geneva Conventions, the GATT Treaty. In the field of investment arbitration and law, which is my expertise, we developed a network of international treaties as well as a system of independent justice in the form of international tribunals. And this, the idea was, that would provide the framework for scrutiny of states' conduct. If a state would violate property rights, there will be a system of justice that can review the state's conduct and probably award damages. So that was the main idea for the expansion of law. But at some point, international law, it seems that has reached the point of saturation, of excess. And so politics now, and states, and sovereignty is claiming back the field. And is this obvious in a number of decisions in Europe. The European Court of Justice has issued decisions that has made decisions about public policy and investment law outside the scope of international tribunals. But we see it everywhere in the world, with the imposition of tariffs, with the withdrawal from international treaties, especially in the global south. We witness a massive exodus from investment treaties from them. So that's more or less an overview of how the pendulum shifted from international law now to sovereignty and national states' power. The two criticisms there are a number of them, but let me focus on the more fundamental ones. The first one is that more international law was thrown at international tribunals. So the more international law was given to the tribunals, the more cases, more matters of international law tribunals will take. The problem with that was that most of the questions that were laid at the feet of international arbitration and tribunals were effectively political questions, policy questions, dressed up as international law questions. So there was an augmentation, a saturation of international law, completely taking over all policy questions that were initially, traditionally, within the discretion of national states. So that was the first point of criticism. Now, the second point of criticism was that not only lawyers and international tribunals would take up more questions of international law, but they also engaged in judicial activism, pushing the limits of international law to a state that now almost every question, every policy question can be expanded the protection of property rights, sometimes at the expense of national sovereignty. So what we really had here was the expansion of international law through dressing up questions of policy in language, in the idiom of legal discourse, and the judicial activism that pushed the limits of jurisdiction to the limits of international law to its limits. I think the way that we are currently doing things requires rethinking. The problem with that is that any sensible proposals for reforms are now considered by states as too little too late. So if we want to seriously address the inadequacies of the current system, I think we need to find other principles to mediate in a coherent and principled way between what is political and what is international law. What I would submit is that this principle lies in the idea, the concept of the public interest. Current legal doctrines of international law do not, in my view, protect and account properly the idea of the public interest. What we need to do is see that international law cannot of itself address questions of public interest. Why? Because public interest is a concept that transcends disciplines, transcends different boundaries. And therefore, we need the expertise from other disciplines to define what is public interest. We need expertise from economists, from political scientists, from sociologists, from the disciplines of public policy and environmental law. We need, therefore, more resources to conceptualize the public interest, and we need standing commissions rather than ad hoc tribunals that comprise not only of lawyers, but also from experts from other disciplines to be able to adjudicate in a more fair and coherent manner the questions that involve the protection of the public interest.